They are admitted. Is live on, Charlotte? Yep.
Everyone.
Okay. Good afternoon, everyone, and welcome. I'm Chris Boyle. For those who don't know me, I'm Head of Employment at Atherton. Today is the 8th of December, and this is a live Q and A on Brexit, what we know, what we think, and what we think you need to know. Thankfully, I'm not answering any questions today. I'll just read them out. But I'm delighted that we have a panel of 4 of my colleagues from our commercial and immigration teams who are going to make up the expert panel today, in which you can submit questions to. So just by way of introduction, we have Jon Esner, who's head of the commercial team. Hi, John.
Hi, Chris.
We have Rachel Atherton, who's a senior associate in the commercial team and specialises in data protection laws. Hi, Rachel.
Hi, everybody.
Claire Hynes, who's a solicitor in the commercial team and specialises in commercial contracts. Hi, Claire.
Hi, everybody. Hi.
And Angela Barnes, who is in the employment team, deals with employment matters, immigration matters, and such like. So, if you have any questions for the panel, please submit the question in the chat box, and we will then go to those in order of them being submitted. If you wish to actually ask the question live, then we would normally say just put question in capitals within the chat box, and then we'll come to you, so you can be unmuted, and we'll take the question at that stage. I do already have some questions that have been sent in. Thanks for everyone who submitted those questions in advance, and I'll be asking the panel these as we go along, and I will stop if any come in through the chat box. So today is the 8th of December. It's 17 days till Christmas. But more importantly, it's 23 days until the end of the Brexit transition period. And we know that there's been various negotiations going on, and we are waiting with bated breath as to what the outcome of those agreements are going to be. So, John, I'm going to come to you first, if that's okay, because I know from our previous discussions that you're constantly glued to Sky News, watching for the outcomes of these negotiations. So just in terms of where we are with Brexit and the transition period and the ongoing negotiations, what is the current position?
Thanks, Chris. I suppose it's all about dates at the moment. One of my particular bugbears, just one of them, in the way that the media reports the situation at the moment, is that they're constantly telling us that Brexit is going to happen at the end of this year. Well, of course it isn't. Brexit, as in the UK formally leaving the European Union, happened on the 31st of December 2019, when the UK left legally, but remained in the European Union, subject to EU law, part of the single market and the customs union, and benefiting from EU treaties, but moving out of the political institutions. So, in effect, to you and me and to businesses, very little changed. Now, that transition period is due to come to an end at the end of this year. We had an option, the UK had an option on the 1st of July to request an extension of that transition period. The UK, of course, did not exercise that option. So it will end. It will end almost without a doubt at the end of this year. In terms of the other dates, which are governing the process, it was expected that the European Council, due to take place on the 10th and 11th of December, so imminently, would be the European Council, the meeting of the leaders of government, at which any deal that was agreed would be informally approved. That is looking, given where we are, increasingly unlikely. And there was also a provisional expectation that the European Parliament would meet on or about the 28th of this month to approve any deal, because, of course, the European Parliament have to approve the deal. And we're also expecting that the deal, because it's not just a trade deal, it applies to lots of other areas, will need to be ratified by each European member state. So where does that leave us? Given, of course, that Boris, we believe, is due to go to Brussels either tomorrow or Thursday in terms of fixed dates. Well, as with many of these negotiations, it's looking, I think, as if the only really fixed date is the end of this year. As I've said, the transition, legally, it's very, very difficult to see that transition period can be extended. It is possible, I think, given where we are, that there could be various devices used to try and make any agreement that is reached before the end of the month work. So, for example, an agreement could be agreed and it could be applied provisionally with member states due to ratify next year. We could have other tricks that have been used in the past, like review clauses, where we have agreements on things that are fixed and then we agree to review other things. So I think if an agreement is reached, we can expect perhaps those kind of devices coming into place. And indeed, the European Union said this morning that even if an agreement isn't achieved, they would expect talks to continue after the end of this year. They are not averse to that. Although, of course, transition would have ended and we would then be in a no-deal position. So I think that is where we are. A few days yet to run, a deal possible.
Okay, thanks, John. And I'm just going to come to a question now. Thanks, Michael, for submitting the question, Michael Horn. And this is probably for Rachel, I would imagine, or correct me if I'm wrong. Hi, Chris. GDPR question. If a UK company is part of an international group and currently under the BCR regime, where an EU overseas data protection authority is the main authority, Denmark, does the UK company need to do anything in preparation or not regarding passing data back to EU companies?
Okay, thanks very much for that question. So if you've got BCRs in place and you're in the UK, so currently your BCRs will legitimise your restricted transfers within your group.
Yeah, that's right. That's what we're being told is we have nothing because the group has BCRs throughout the group, and that includes non-EU countries as well. Which has already been set up and approved by the relevant data authorities in the different countries, supposedly. So I'm being told from our head office. Our head office are currently saying that we have nothing to do, whether it's a deal, no deal, or whatever happens. We can still just carry on as normal.
Yeah, I mean, in terms of the bigger picture for data transfers, even if you didn't have BCRs in place, if you're the UK company and you're transferring personal data outside of the UK to other European Union countries, there's nothing to do in those circumstances, because the UK, that is the position that the UK government has taken. The issue possibly may arise with transfers from the EU into the UK, because
which there are transfers like that.
There are transfers like that, but really that's going to be the responsibility of the part of the organisation that's making that transfer. So certainly within the UK, I don't think probably there's anything that you need to do differently.
Yeah, that's what I'm being told of our head office. Our head office are telling me that we have nothing to do, just forget about GDPR and everything else. whichever way Brexit goes, because we're already sorted out.
Yeah, I mean, there might be questions for the parts of the business that are within the European Union, because of course that transfer, there are some changes to BCRs, only because previously the UK was part of the European Union, so it was in the club.
Yeah.
It may be that the supervisory authority that approved those BCRs may need to be spoken to see if there's anything else that needs to be done, but that wouldn't be a concern for the UK part of the business, I don't think.
No, that's great, Rachel. Yeah, all I'm interested in, to be frank, is what we have to do. What anybody else has to do with the group's their problem, not ours, basically.
Yeah. I mean, in terms of transfers out from the UK to the rest of the world, if you're relying on those BCRs to make transfers of personal data outside of the European Economic Area and outside of countries which may already have an adequacy decision from the European Commission, then you may need to speak to the Information Commissioner to reapprove them. But it depends. You really need to think about what the transfers are. It's obviously every business is going to have different transfers of personal data, so it's worth having a think about them. But if you've got your BCRs in place, then the transfer into the UK is going to be a question probably for the Norwegian part of the business, I think.
Yeah, fine. Yeah, no, that's great. That's what I understood it. That's what I've been told from our Danish colleagues who actually control it all. They've said, because everything what we transfer out or they transfer in comes via Denmark, if you like, in simple terms. So everything's coming, even if it's coming from a Canadian operation, which we have, it comes via Denmark to us and vice versa. So everything goes via Denmark. That's the way they set it up. And it's the Danish data authorities who've approved it all and got approval from our Information Commissioner, etc. originally when it was all set up.
Yeah, there might be a slight question mark over that in terms of relying on it to transfer away from the UK. That's probably one to pick up in a more detailed conversation, I think. The guidance is detailed.
Okay, thank you.
Thanks, Michael.
Thank you.
Thanks, Rachel. And then we've just got a second question in the chat box there from Nadeem, from Panaz. This is a very broad question, but John, you don't know whether you want to pick this one up. What is the issue of the UK breaking some rules that reported in the media recently, and how will this affect the agreement? This is presumably references in Nadeem to the ongoing prospects of alleged breaching of international law by the UK government.
Oh yeah, yes. This is, I think, the famous internal markets bill. Yeah. Yes. I mean, I suppose winding things back a bit, this goes to the withdrawal agreement. This is the agreement that the government signed at the end of last year, which dealt with a number of issues. One of which was the issue of Northern Ireland and the Irish border, and in order to square the circle, so to speak, of how the UK would maintain its own internal market, but at the same time maintain a frictionless border between Northern Ireland and the Irish Republic, there was in effect a decision to keep Northern Ireland in both the UK and the European Union customs areas. And you can see in itself that was likely to create some issues. Now, in terms of the effect that's likely to have, it creates in effect a customs border between Northern Ireland and the rest of the UK, and a committee was set up to deal with how that was going to be managed. The internal markets bill has been proposed as a fallback position in the event that the government does not get the results that it wants from the joint committee between the UK and the European Union on the rules governing goods passing between the UK and Northern Ireland. So what it says in effect is, if we don't get the outcome we want in the committee, which incidentally met yesterday, I believe. I think we have some pictures of Mr. Gove going out to Brussels to meet his opposite number, Mr. Sefcovic. The IMB, the Internal Markets Bill, says that if the UK doesn't get the result it wants, it will in effect overrule it, which clearly did not go down very well with the European Union, because of course there's a dispute mechanism in the treaty to deal with disputes. And on that basis, the European Union pointed out, and this is not a controversial point, that it would be, I mean, the government admitted as much itself, that this would be a breach of international law. I think we can all guess that there are political reasons behind this particular bill, and it was again reported yesterday that the government was suggesting that if there were to be an agreement reached, that they would drop these controversial clauses in the Internal Markets Bill. But of course, like everything else, we'll have to see.
So, in terms of the outcome of that alleged or the breach or otherwise, I guess we don't know really the outcome, do we? In terms of what the consequences of that are.
I think the practical consequences are that there will not be an agreement. There won't be a trade agreement. The EU have made very clear they will not sign a trade agreement unless the IMB is dropped.
Okay, great stuff. Does that help, Nadeem? Yep, good stuff. Excellent. That brings me nicely on to Claire. I'm going to come to you now, Claire, just to pick up on some of these issues around the lack of, as it stands, a trade deal. Of course, we don't have one in place at the moment, and the impact of that, I think, as everyone's been talking about the last few weeks, is that we effectively would revert to WTO rules, World Trade Organization rules. So, just in terms of your opinion, I mean, if I'm a business now and I'm looking ahead and thinking, should I be taking action? Should I not be taking action? Should I simply wait and see what happens in terms of a trade deal, or should I start taking some steps to prepare now?
Thanks, Chris. Yeah, I mean, it makes absolute sense to start taking steps now. To the extent that you haven't already, I'm sure most organisations are undertaking some sort of Brexit audit or risk assessment, and I would imagine that many of you are already well on with that. Now, I think Jon mentioned this at the very start, that one thing that hasn't been well communicated at all, and the message seems to have got lost, is the fact that a trade deal will only address certain factors. It won't alleviate or remove the need altogether for customs controls, and fundamentally from the end of the transition period, those controls are going to come into place and into effect, and organisations do need to be ready for it. You're right, it's incredibly difficult to get this close to the point where people would like some clarity on exactly how the land lies and what their position's going to be. Of course, a trade deal would deal with matters such as zero tariffs and quotas, but it could also ease some restrictions for customs processes, but not remove them altogether. So I think that the sensible approach is prepare as though there's no trade deal in place. You are, deal or no deal, as everybody says, going to have to address customs formalities in any event. So get those processes in place and start making sure you've got everything that you need, all the information, the personnel, the software, everything in place that you will need to actually bring that into force in effect.
That's good, yeah. And then in terms of, I mean, I was actually looking on the British Chamber of Commerce website yesterday, and I think they were saying that there's 24 out of their 35 questions on their Brexit guidance dashboard. There's 24 questions not yet answered by the government, which is not particularly helpful. But if I have never traded outside of the EU before, what should I be now looking at?
Yeah, I mean, it's an incredibly broad question, and to answer it in detail and go through step by step would take way in excess of the time we've got today, and probably the rest of the afternoon actually. But I think the key sort of practical steps that every organisation should be taking, hopefully are already on with, as I say, a full Brexit audit. Have a look at your business, have a look at your supply chains, have a look at your customers, the trade agreements that you've got in place, what Incoterms do you trade on, what are your responsibilities and obligations as regards customs duties, declarations, where do you sit and where are your customers, what goods are you dealing with. There's lots of specific legislation and regulation around goods that's very good specific. So it's not enough to have a broad brush approach of you'll need X, Y, and Z. You need to look in particular at what goods you're importing or exporting to see what licenses might be required, if dedicated points for importation and exportation are required. All those matters need to be looked at. I think one of the absolute keys is going to be making sure, if you do your assessment and you are going to be importer or exporter of records, making sure that you've got those intermediaries lined up. For businesses that have obviously been trading globally and outside the bloc for some time, this is going to be much less of an issue. I'm sure they'll have those relationships already. They'll have some familiarity with the system. For organisations that are completely new to it, it's a really, really complicated area. You know, finding your commodity code alone can be, you might get that golden ticket and your particular product is quite easy to identify, or it could be one of the, I think, nearly 12,000 commodities that's, you know, in there, and it's quite difficult to pin down. So I think the key is going to be making sure that you've got third-party assistance, you've got people lined up. Added to that, I think it's no secret really that there are grave concerns of an undersupply in that particular sector. Customs intermediaries, the requirement for them is going to absolutely skyrocket. I've heard loads of different figures bandied around. From 2020, there's been, you know, maybe 50 million, 37 million declarations, which is going to rocket to over 250 from 2021. So all of a sudden that sector is in huge demand. And unfortunately, obviously, with the year that we've had this year, the plans and the infrastructure and the funding that was put in place to get people skilled up just hasn't really probably got us to where we need to be, because people's attention has been very rightly diverted elsewhere. So it's getting contact with those organisations, do some due diligence into who you're dealing with, what sort of measures do they have in place to try to help you achieve what you need to, particularly when you know, subject to critical time constraints. Whoever you engage, do they have the capacity to help you out at this point? What measures have they got in place if some of their agents are unavailable to work, for example? So that's probably the most practical advice I can really offer, is to make sure you've got those contacts. And if you are, even when you are appointing third-party intermediaries, I think it is a really good idea to make sure you do have the knowledge internally as well, even on a basic level, so that you know how to instruct those intermediaries. You can give full and detailed instructions, and you have got some good awareness of what's going on there as well. In terms of if it's something you're going to bring in-house, you'd obviously need to get the right personnel on board. There will be a whole raft of measures that you'll need to implement. So access to the relevant systems, the chief system, for example, national export system, licensing the right software that speaks to those systems, making sure very, very fundamentally, every organisation will need a GB EORI code, making sure you've got that. Like I say, ensuring you're clear on your commodity codes. Normally, you can get a binding tariff request. You can request that from HMRC to give you some protection that you're trading on the right tariff, that you've got the right code. That can take a while to come through. So it's unlikely that an application now will get that in place in time. Fundamentally, you can get a non-binding steer from HMRC, or you can appoint consultants to help you. So sorry, it's an extremely broad brush answer, and I appreciate I'm probably firing lots and lots of different pieces of information, but the key takeaway is sit down, look in your organisation, make sure you've mapped out exactly where you're likely to be impacted. You've got the right people in place to assist you with it going forwards.
Yeah, no, it's a huge area. And in terms of government, just briefly, in terms of government support or government offering to support, certainly first-time exporters or importers who are kind of stepping foot into this field, what sort of support is there out there?
Well, in terms of practical support, there is funding available, grants for training. Again, I don't think this has really been widely publicised. People that I've mentioned it to have never heard of it before, never come across it. So you can make an application. I think PwC are actually administrating the process, and you can apply for some basic customs training as a trader for, I think, up to £1,000 per organisation. Now, that's really aimed at traders who will be appointing intermediaries to work for them, but it gives you that foundational knowledge, and it'll help you going forwards, like I say, to work with those intermediaries and just, try to work your way through this completely foreign landscape. So that's one element of the training. There is also funding available for recruitment and employment costs of people that you bring into the business to help you complete customs declarations. So you can get, I think it's up to £3,000 for recruitment costs. So that would be, maybe your recruitment fee, temp to perm figure that you might have to pay, and up to, I think it's £12,000 for employment costs as well for people that you bring into the organisation. There's also some further, I think it's funding available for more the intermediary side of things. It's co-funding projects, and there's higher levels of funding available there under the general block exemption. So there's that side of things that's particularly could be useful if you're able to pick that up and take it forwards. Like I said, I think it's PwC that's administrating that. If you want to take a look and see what's available and try to get yourself as skilled up as possible. Second to that, I think really probably the most helpful thing that the government has done for businesses in the UK is the phased approach to importing into Great Britain. So the full-scale customs procedures aren't going to apply until the 1st of July next year. It gives everybody a little bit of breathing space. This is for standard goods, I should point out as well. It doesn't, the phased approach doesn't apply to controlled goods. So from the 1st of January for sort of standard goods, as it were, they will, you'll have up to 6 months to submit a full declaration and pay any tariffs payable. What you do have to do is keep a record yourself of what you've brought in. There's a list on the government website that details quite neatly what you have to keep a record of. So the commodity code, for example, the quantity of the goods, the date it arrived with you, the customs value. And that all needs to be recorded somewhere on they call it the declarants, the importer's own system somewhere. That could even be an Excel spreadsheet, but it would need to be recorded and kept somewhere in case it's ever open to inspection. So I think that's probably one of the most useful measures that's been taken. And I think that was really as a result of COVID and a recognition that that's put businesses back by, a good number of months. And that should ease things for importers in the immediate term.
Okay, thanks, Claire. We just got a question in there on the chat box from Carl Gamble. Thanks, Carl. Is there any indication as to what the parcel value threshold will be for e-commerce traffic going to EU member state consumers?
I'm not sure on that one off the top of my head, actually. I'd probably have to look at it again, unless John or Rachel have come across that already.
No. Okay. No, we'll have to come back to you on that, Carl. We'll take
we can have a look at that.
We've got your details, so we'll come back to you on that. Okay.
Make a note.
So there was one thing that that came up in conversation the other day that we were having, and that was around tech, but specifically around the and the Amazon Fulfilled by Amazon scheme that they run, which obviously is there as a route to market for smaller businesses. I just wondered whether you had any views on that, and I guess the potential difficulties that this is going to cause that scheme.
Yeah, unfortunately, I think this has caused a lot of consternation to smaller businesses who have used Amazon as a means of getting their product to a much larger customer base in the EU. And Amazon came out relatively early doors, I think it was July, and said that their Fulfilled by Amazon FBA service in Europe would no longer be available to people. So previously you had two ways of selling via Amazon, as a direct seller fulfilled by merchant, or via the Amazon fulfillment centers. And Amazon offered a couple of different routes to market under the Fulfilled by Amazon mechanism. And that enabled you to have your goods either located in a UK fulfillment center, and the Amazon would deal with fulfillment out into Europe, or Amazon had another service whereby they had quite well developed coding or algorithms that figured out exactly what goods needed to be where in the 6 European fulfillment centers, and they could move your relevant goods around to those fulfillment centers. And I suppose that would help with your kind of Prime membership, because it means you've got your goods are there and they can be sent out quite quickly to the relevant places. And it was an exceptionally useful service for businesses to have that access into Europe and just pay a fulfillment service fee effectively to Amazon. But Amazon have obviously said that can no longer happen. We will store your goods in our European fulfillment centres, but you will need to have an EU EORI number to do that. You might even need a fiscal agent in some territories as well to work for you, VAT registration, and you'll have to decide which goods go to which fulfillment centres in Europe. And the administrative burden very much passes back to the UK seller. And it's an additional problem to that is, you've got to figure out what needs to be where, when. You can't rely on Amazon doing that for you. You've got to pay storage fees on those fulfillment centres in Europe to Amazon, which can add added costs on as well. So it's unfortunately left some smaller businesses in a more difficult position, and wondering whether they do carry on using the Amazon EU fulfillment centres in view of those extra responsibilities they will have going forwards.
That's great. I've got a question which I want to go to Angela to in a minute, but just one final point for you, Claire, 30 seconds if possible. There's potential for border delays, obviously, after the 31st of December. What, if anything, can employers do to try and protect against that, or the consequences of that?
Yeah, I mean, this is one of the areas that's giving people the most concern, tariffs aside, and the increased costs, of course. Border delays are causing great concern, especially when you've got very, time is of the essence, time delivery commitments to your customers. So I think in terms of practical measures, it's trying to make sure that, your trucks isn't going to be one of the trucks sat there without the right documentation, getting those practical measures boxed off and being fairly confident that you'll have the right paperwork there as and when you need to leave the port. Easier said than done, obviously, but that's something that is generally within your control, that side of things. taking a wider picture, it's maybe assessing if there's other ports that you can use further north that might be less congested. Are there even other mechanisms or the modes of transport that you might be able to use to shift your goods? So taking a broader approach than that. Then I think in terms of actually respecting and protecting your contractual position, that really comes down to having a look at what you've agreed with your counterparty. When are they expecting the goods? What's the impact of your goods being late on your liability under that contract? And there are various measures that you can try to include and negotiate into your contracts, which I believe is something Jon is looking into and might be able to expand a bit further on.
Yeah, okay, that's great. Jon, I'm going to come to you next. Angela, I'm going to come to you shortly after that. But before I go to Jon, I've just got one question in the chat box from Laura Wright, and we may cover some of this, although I'm looking at the clock. I'm struggling to find much information relating to the movement of people overseas from January onwards in terms of work visas, etc. Is it just a case of looking at each individual country's requirements separately, or is there likely to be a blanket visa that covers most all EU countries?
Yeah, thanks, Chris. So the position is we don't know yet whether it's going to be one blanket policy across Europe or whether it's going to be just a case of each individual having to meet the requirements of a particular EU state. Obviously, they're trying to get an agreement that's broader brush than just individual country requirements, given the logistics of it. It may be that there are common themes across all of the EU countries. So, for example, there might be visa-free travel up to 6 months. That's been talked about, and then after that point, visa required, but it might vary from country to country. The other thing that we might see is there might be a blanket policy agreed for the European countries, so the EU countries, but then with EEA countries, which are slightly different. So we're looking there at Iceland, Norway, and Liechtenstein. There might be separate policy agreed for those 3 countries, and then again with Switzerland, that's in a category on its own outside of the EU. There may be a separate agreement there. So the short answer is we're not sure. I'd like to think that there is some sort of blanket visa that would make my life a lot easier, but we just don't know what that's going to look like yet.
Thanks, Angela. I hope that answers the question, Laura. Jon, handing over to you now. Commercial terms and conditions of contracts. I guess if I'm a company and I export to the EU now, I'm going to be potentially concerned about existing arrangements. Are my T's and C's or my contractual arrangements suitable? What should I be looking to do now?
Thanks, Chris. Yes, I think as an exporter, and to a certain extent as an importer as well, you're going to have 2 major impacts: costs, and Claire has run over some of those in some detail: customs, tariffs if there's no deal, and regulatory costs as well if you're in a regulated area. And of course, the other great likely consequence is delay. There are going to be delays at ports. We know that there's going to be a requirement for a Kent pass, etc. The government is very much expecting that there will be delays exiting the UK. So what do you do? I mean, again, Claire pointed to some practical ways around that, potentially looking at other methods of export. In terms of your contractual requirements, first thing to do, of course, is get your agreements out. Have a look at what they say. Have you signed up to firm time commitments on delivery? Are there specific times you've got to deliver for? Do you have detailed KPIs that you've got to comply with? If you have, what are your contractual remedies? Well, if you've got a detailed contract like that, that's gone to the extent of giving these kind of detailed commitments, it's likely that you may also have a force majeure clause. Have a look at that force majeure clause. It could be very important because force majeure clauses often cover governmental actions, and it's quite likely that these kind of delays could fall within the force majeure clause, and it could be very helpful to you. Read that clause very carefully, because it normally is in order to benefit from a force majeure clause, you've got to do things. You've got to comply with it absolutely. So, for example, do you have to give notice to your partner, to your buyer as soon as possible? Do you have to take actions to mitigate? How long does this clause last for? For example, a lot of clauses say that after a certain period of time of you not being able to perform, that one of the parties can give notice to terminate. So read it, look at what it gives you. But it's very important, of course, above and beyond what's written down in the contract, to be in contact with your customers. Your customers are going to be very aware of what's likely to happen. And as an aside, I think just as with COVID, for the first time, a lot of these clauses were put into agreements, people are going to be reading them very carefully. And I'm afraid we do expect to see lots of litigation arising from how these clauses can be interpreted. In terms of costs, again, have a look at what your agreement says. If there are going to be costs of customs, costs of tariffs, who's going to pick those up? And of course, the normal position is that, although by no means always the case, is that costs are fully inclusive other than VAT. But that will differ from case to case. So have a look and see what the position is. Do you need to renegotiate? Is renegotiation possible? We have been seeing increasingly the use of specifically drafted Brexit clauses, which allow parties to exercise options such as to amend times, to increase prices, to make sure that tariffs are taken account of, for example, to terminate if there's excessive delay. We're also seeing as well now increasingly the use of hard Brexit clauses that say in the event that the UK exits the European Union without a deal, this is what will happen. These are the additional rights that the parties will have. So although that's probably not something that is going to be possible to negotiate within the next 2 or 3 weeks, I think we're going to see those as an increasing fact of commercial life. But overall, read your agreements, take advice, and also make sure that you take advice from other experts in the field in relation to VAT, in relation to customs, and in relation to the regulatory requirements that affect you if you're in a regulated industry.
Thanks, John. I'm just conscious of time, so I'm just going to move on to Rachel now, just to deal with some of the GDPR implications, I guess. And what are the data protection implications of Brexit, and how will they impact UK businesses?
Well, there's a number of things to be concerned about. Assuming you're a UK business, then of course the GDPR itself from transition day will not directly apply to you anymore, because it's a European Union piece of legislation, and if we're not a member state, it won't apply to us. But before anyone gets too excited about the prospect of not having to comply with the GDPR, what the UK government is doing is they're going to put into place an identical piece of legislation which we're going to call the UK GDPR. So this is identical to the GDPR, except it's had some changes for sense. So, for example, there's no reference to member states and things like that, but it's essentially the same piece of legislation. Now, if you're in the UK and you've got customers in the UK, then that's the law that you're going to have to comply with going forward. However, now that there'll be 2 separate regimes, it could be that they could change over time. Obviously one of the whole things over Brexit was having more kind of autonomy over law. So it could be that those 2 regimes diverge over time. Now, of course, exactly how it will impact your business, the change from a data protection point of view, depends on how your business is structured, and it depends on where the people whose personal data you're processing are. if you're, for example, if you have customers in the European Union, then you're going to because if you're offering goods or services to those customers, in the sense that you're targeting them with goods and services, or if you're monitoring their behaviour within the European Union, then you will have to comply with the GDPR itself anyway, which hopefully you already are doing because it's essentially the same as the UK GDPR. But one of the things you will need to think about is whether or not you're required to appoint a representative in the European Union. So this is what the GDPR says is, it says if you're not established in the European Union, so this is a business that only has an establishment in the UK, for example, post-transition, post the end of the transition period, then if you're going to be offering goods or services to data subjects in the EU, or if you're going to monitor their behaviour, then you need to appoint a representative in the EU to be a contact point for those data subjects and also for the supervisory authorities. And I think this is, I mean, it's probably fairly straightforward. You'll know whether or not your customer base is in the European Union, although there is actually quite a lot of guidance on what those two kind of threshold terms mean. The other one about monitoring the behaviour of, well, you might think, well, what does that mean? And there has been some guidance issued on this, and a lot of it could come from the more technical aspects of what businesses do. So things like if you're using a lot of tech to kind of track and predict behaviour, like perhaps you're using tech to serve ads based on location or that sort of thing. Perhaps you're selling services whereby people can, input what they ate that day and how much exercise they took, any sort of wearable smart devices which collect information from that person. All that will count as monitoring the behaviour, and you will need to appoint a representative in the European Union. And if you need to do that, you'll need to, in fact, you don't need to appoint one if the risk is very low. So if you're doing something very, very basic with the personal data, for example, and so you'll need to carry out an assessment to decide, what are we doing with the data, what's the risk, and do we need to appoint a representative? But if you do need to appoint one, you'll need to do that in writing. There has to be a contract in place, and you've got some obligations about the information that you have to give to that person. And then more broadly, of course, you'll need to update your privacy notices because, if you've got a representative in the EU, you need to tell people about it, tell supervisory authorities about it so they can find that information should they need to get in touch with you about your data protection practices. And then, of course, the one which the question earlier, which was about binding corporate rules, but that kind of comes under the international transfer of data sort of bucket of questions, which, depending on what you're doing with personal data, the answer will be different. But at the moment, because we're in the European Union, data can flow freely, personal data can flow freely between the European Union countries, or the EEA actually, and the UK. Now, I don't think this gets enough publicity actually, because I think it's it probably has a potential to affect quite a lot of businesses. But if you're transferring data from organisations in the EU, then you're going to have that is now a restricted transfer, and it needs to be protected by one of the mechanisms that's available or under a derogation. So, for example, if you don't have BCRs in place, and lots of organisations don't, most the only organisations that tend to have BCRs in place are probably quite sophisticated, large organisations actually that have gone through the trouble of putting them in place. Otherwise, you're going to have to rely on something like the standard contractual clauses to make that transfer. Now, it's important to note with that if you're in the UK receiving data in from an organisation in the EU, then actually it's their lookout, because they're the ones that have to comply with GDPR. On the other, if the boot's on the other foot and you're transferring data out to the EEA or the EU, then the UK government has said that's fine, you can carry on doing that, that's okay. And of course, if you're transporting data to the rest of the world, perhaps to a cloud services provider in the US, for example, you'll basically need to do what you were doing at the moment, provided you are complying with the law, because that would be a restricted transfer under the GDPR, and it would also be one under the UK GDPR. So I think that there's quite a lot really, I think, to take in there.
Yeah.
And what will be relevant and what you'll need to know about will depend on what it is that you're doing with personal data. So where are your customers? Who are your customers? And what kind of transfers cross-border are you looking at? Do that bit of analysis, have a think about it, and then perhaps then take some advice and make sure you've got everything in place.
Yeah, that's great. And again, if anyone needs any advice, I'm conscious of time. We've only got an hour, but if anyone does need any further advice, then we'll be sending through information afterwards with a link to book in for further advice if you need it. So you'll all get that through. Okay, thanks, Rachel. Just moving on now, Angela. Employees, workers, the effect of Brexit on the UK workforce has probably been much talked about over the last few weeks and months. But do you just want to explain what the position is now currently for EU workers who are in the UK now?
Yeah, thanks, Chris. So for EU workers who are here now and EU citizens generally, free movement's carrying on. We've talked about the transition period, and nothing really changes for them up until the 31st of December this year. So in terms of document checking, etc., nothing changes. They don't need to supply any further information to their employer. What they are being encouraged to do is to apply for the EU settlement scheme, which you've probably seen about in the news. So this is where EU citizens can formalise or legalise, if you like, their stay in the UK. And it's a 30-minute application form at its quickest. If you've got a national insurance number, it's a very speedy process. And the EU citizens who apply, as long as they reside here before the 31st of December 2020, they will be granted either settled or pre-settled status, depending on how long they have continuously resided in the UK. And as I said, the key date is the 31st of December. They need to be here before then, but they can apply along with their family members up until the 30th of June next year. Still, the government encouraging them to apply sooner rather than later, so that they have the paperwork in place really to prove their stay beyond the 30th of June 2021.
And the new system, the new immigration system, otherwise referred to as the points-based system, you just want to give an overview of that system and how it works in terms of its parts.
Yeah, so this is the system that will be introduced with effect from the 1st of January 2021. So it applies equally to EU workers who are coming in after the 31st of December this year, as well as to non-European workers, as it has done previously. So there'll be no distinction of treatment between EU workers and non-EU workers from the 1st of January onwards. And you're right, Chris, it's a points-based system. We had understood it to be this radical, revolutionary new system. It's actually quite similar to the system that we already had for non-EU workers previously. But you know, the key difference is it's going to be a lot harder to employ EU workers from the 1st of January onwards, because they are going to have to meet a certain points threshold under this new system if they want to come and live and work in the UK. And as we know, you know, one of the stated aims of this new system was to reduce overall net migration. And the way that this new system does that is by making it much more difficult to get lower skilled, lower paid individuals into the country from outside of the UK. And it's easier, I guess, to bring in skilled workers. So as long as they're being paid at a certain amount, a certain level, and they have a certain level of qualification, level of English language, then it's easier to bring those skilled workers into the country. But as you can imagine, it's very difficult for those employers who rely on maybe a lower skilled, lower paid workforce, you know, particularly in sectors like the care sector, manufacturing, hospitality. You can definitely see those industries being hit hardest through the introduction of the new system.
And so just on those lower skilled workers and the requirement for businesses, or the businesses that are currently using that aspect of the workforce, is it just a question of them looking to the UK market as opposed to bringing in employees from overseas? Or
Yeah, I mean, that's what the government is urging employers to do. They're looking at employers to use the settled workforce. So if, you know, for example, they're trying to say that, you know, can employers embrace technology better, make efficiency savings so that they need fewer number of employees in the first place, but also can you diversify your search pool, so make it easier to get people back into work again from the settled workforce. So whether that's by having different contracts that allow people to work more flexibly, or lowering, you know, degree level standard jobs maybe don't need a degree and they can, you know, so as I said, the government are trying to get employers to use the UK settled workforce more effectively as an alternative to employing those people from outside of the UK.
And if I'm looking to apply for a sponsor license, what sort of things should I now be thinking about before making that application?
Yeah, so if as an organisation you've decided that you do need to continue to employ EU workers and non-EU workers, the way to do that under the new system is to apply for this sponsor licence. You won't be able to employ EU workers and non-EU workers from outside of the UK without a sponsor licence. I suppose the things to think about, it's not cheap to get a sponsor license, so there is an upfront application fee, and then there are fees associated every time you want to bring a worker in on your sponsor license or into the country. There are costs associated with that, so there's the cost element. There's also administrative responsibilities. So in bringing those workers into the country, you are, if you like, as an employer, acting in a quasi-parental role in terms of reporting and monitoring, making sure you know where those staff are and reporting that back to the border agency, so that if somebody, for example, who is a sponsored worker doesn't turn up on their first day of employment, you as an employer, as a sponsor license holder, would need to report that to the border agency. So there's, as I say, there's a cost element, there's an administrative element. However, having said that, you know, I'm receiving getting queries from a lot of clients about a sponsor license, because without one, you won't have access to that pool of workers that you've previously come to rely on.
Yeah, and then just finally, in terms of preparation for the new system for the 1st of January, what sort of things are you now suggesting employers should look to do? Yeah.
So the key word that I've been talking about a lot lately is audit. So first step is to find out who your workers are. You know, have you got many EU workers? If so, how many? You know, are you going to need EU and non-EU workers going forward? Because only with that information, then can you make a decision about what you're going to need to do going forward. The other element that I'm advising a lot on is how employers can support their existing EU workforce with applications for the settlement scheme, because, you know, some EU workers just simply don't know how the process is run, what they need to do. So employers are more proactively trying to help their staff with that process. So that's another thing that I would suggest that you do. See if your EU workers need any assistance. And then once you've got all of that information, then make decisions about, do I need a sponsor license? Is it going to prohibit my business if I don't get that sponsor license? And you know, there are other things that clients are doing. So for example, they're looking to bring in EU workers now before the 31st of December, even though they maybe don't require them, and maybe it's seasonal work, for example, so agricultural clients, bringing them in now, and just so that they're ready and have the basis to be here lawfully in advance of next year. So there's creative ways of working around the system, but as I said, the most important thing is to make those decisions about how you're going to manage with this new system going forward.
Yeah, and just one question, actually, I missed off the chat box, which is from Emma Reed. Is there much information around the movement of staff across EU borders, timing out UK for meetings, working in other locations cross-border on short-term, long-term basis?
And this is definitely the area where the information is lacking. We know a lot more about EU workers coming into the country for obvious reasons than we know about UK workers working in Europe or travelling for business. Yeah, I'm expecting there may be similar arrangements for European countries. So, for example, if people need to go to visit countries to attend meetings, etc. I would assume there will definitely be some flexibility there rather than requiring a specific visa, but it's unanswered questions at the moment, Chris.
Interesting one, that, yeah. And then just one more, Angela, for you, from Michael Horn. If we employ an EU worker with settled status, so they tell me, do we need to hold any evidence of this as part of their HR file or not?
Okay, so at the moment we don't. So you don't even need to have that information. If the employee's volunteered it to you, that's fine. But I certainly wouldn't be demanding that information from an employee. However, the position, as I've said, will change after the 30th of June, where employees will need to present that information, or we certainly expect that they will at the moment. So yeah, as I say, no requirement to have it, but if they've given it to you, feel free to put it on their file, because there will come a point in the future where you do need it.
Thank you. And then just one final one from Rob Murray Brown. This is a let's end it on a very positive note. Is there anything that we can look forward to by way of positive outcomes? Less paperwork, less expense, fewer delays, etc. Just one thing. Anyone?
Actually, I can share one, which is the border agency historically have been absolutely terrible at accepting documents. So everything has to be original or certified. Through this process, the border agency are a lot better at accepting electronic documents, because, you know, I suppose that's a result of Corona potentially as well, rather than Brexit. But that's definitely a positive, and it's something that they're going to do more of that going forward as well. Hurrah.
Good stuff. Excellent. Positive note we end on. So thanks everyone for your questions. Thanks to everyone for attending. We will send some information out after this. We are running a strategy room, which you may have seen, that we've been publicising on social media, etc. If you want to book into the strategy room, then it's an hour, and you can meet with the guys on this call or any other of our lawyers as well. And you'll see the link when we send that through. But for now, thanks everyone very much. It's been great to see everyone, and I've no doubt we'll meet again when hopefully we get a trade deal. Thank you.
Thanks,
Bye-bye.
everyone.
Bye.
Thank you.
Bye.
Okay.